Hi everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, we're going to go over some basics about how California law treats powers of attorney. So a power of attorney document is a legal document by which a person, called the principal, is able to delegate or give over some decision-making power, some decision-making authority that they would ordinarily exercise on themselves, and they're going to make it so that somebody else can exercise that power for them. So that other person over here is called the agent. So the principal has some power, gives the power to the agent for the agent to exercise for the principal's benefit. So a lot of times people have heard of powers of attorney, but nobody's really kind of defined it. So hopefully that definition I gave is not too confusing. If it is, let me give you some examples. So two common examples that I've run into before is, let's say that you are in the U.S. military and you're from, say, California, but let's say for whatever reason you have to deploy to Korea, you have to deploy to Iraq, Afghanistan, something like that. Basically, you have to deploy outside the United States for several months. So while you're gone, you can't really interact with people in the United States real well. You can't conduct business. So in that situation, it might be useful to give over, say, your ability to go to the bank, etc., and have your mom do it for you, or have your dad or your sister, to basically make it so that your brother, your dad, your sister, some other person can interact with your bank for you, just like your bank would interact with you. Obviously, the person you delegate has to be somebody that you trust, is reliable, all that stuff. So I'll give you another example. Let's say that you're the principal, but you're getting on in years, like you're getting a bit older. You know that your health is not so good. Maybe you have early onset dementia or something, and you know that in a couple of years you're not going to be able to handle stuff on your own. You're not going to be able to file taxes on your own. You want to make it so that you're prepared for when the day comes, and you have somebody there who can take care of your banking needs, your financial needs. Like if you get sued, somebody can take care of that for you. Basically, to handle all of the grown-up stuff, I guess, that when you were kids, you didn't really have to worry about. So that's kind of two very common examples in which a power of attorney is something that would be very useful, I guess. So that said, a very common kind of question that I get, like a follow-on question that I get is, Andy, if I want to sign a power of attorney, do I have to get it notarized, or can I just get it witnessed? So a power of attorney generally, like I just described, is in California Probate Code section 4123, which I'll go ahead and link down below for you in the description. But the power of attorney generally is California Probate Code section 4123. The answer to the notarization versus witnessing question, however, is in California Probate Code section 4121, and specifically it's subsection C that you're interested in. 4121C, again, I'll paste and link it down below for you. But the basic idea, if you read it, is California law can do either one. So if you want to notarize your power of attorney document, you certainly can, and it's fine that way, it's valid after you notarize it. Or if you don't want to notarize it for whatever reason, you can have it signed by witnesses also. So between the two of them, if you can, I generally try to go for the notarization method because it's very straightforward. Just find any notary anywhere, pay them the $5 or $10 per signature, and that'll be that's basically it. If you have to have a notary come out to you, like a traveling notary, there's an extra fee for that typically. But if you find a fixed business where the notary doesn't travel, going to them, those businesses are everywhere. So a lot of times people think that, there's no notary close to me. I would be very skeptical of that. Look a little harder. I'm almost willing to bet that there is. It's probably just not something you've looked up before. So anyway, that said, notarization or witnesses are sufficient. You can do either one. Sometimes people do both. It's not required that you do both, but you certainly can. Maybe it makes you feel better. So that said, if you want to do the notarization way, I typically like that better because it's easy, straightforward, very inexpensive. If, however, you genuinely cannot get a notary to do your power of attorney, you can get it witnessed, and specifically you have to have two independent witnesses. So, if you're going to do it that way, the next question basically is, Andy, who can be a witness? So the answer to that question is in California Probate Code section 4122. So we're all basically in like the 4120-ish kind of section, I guess. So, but 4122 is where they go over who can be a witness. So there's basically two criteria. Number one is that the witness has to be somebody who's an adult. So if you have a child, generally rather, not going to be a good witness. If you have somebody who is over age 18, but for whatever reason their mental kind of state is less than 18, generally not a good idea to use them as a witness either. Anyone who has problems with like perception, or anyone who has problems testifying as to what happened and stuff, generally not a good idea to use as a witness. Best to get somebody else. But anyway, regardless, the first criteria is that the witness has to be an adult. Number two, and this one's pretty straightforward, I guess, is that the agent in fact, sometimes called the attorney in fact, the agent who is being designated in the power of attorney cannot be a witness. That's pretty straightforward because, basically, this person, the agent over here, you just can't use them. You can use basically anybody else who's an adult, just not the agent. So those are the kind of typical questions that I get when it comes to powers of attorney. Number one, what a power of attorney is. Number two, can I notarize it, or do I have to get a witness? If I do get a witness, who can be a witness? So the basically, I guess this is not really a question that I get, but I'll toss this in there also, is that if you are going to be a witness to the signing of a power of attorney, there's two ways that you can do it. You can actually see the principal signing, like the principal can actually sign in your presence and you can witness that. That would be great, I think. The other way is called acknowledgement, and that basically is the principal signs his or her name, calls you over and says, hey, I just signed this is my signature. So the thing is, the admission that is their signature, that's sufficient also. That's called acknowledgement of the principal to the witness. So hopefully that was not too confusing. Go ahead and rewind this video if you want, watch it again, and leave me a comment, subscribe, all that nice stuff, and I will talk to you guys next time. Thanks.